I will pardon to make a mention out of the list.
So today,
No, for Monday, that's a rehabilitation assistance scheme, that's a fresh matter, that case content.
come to Monday.
I will,
Monday list.
New fresh matter.
Not I will pardon, my lord. A habeas corpus matter, my lord. It was listed before, my lord, on 25th August, my lord. And Lordship directed, again, it is not reached. Again, Lordship directed to list it on the 29th, my lord, on my mention, my lord.
Come.
They have not listed, my lord. 15 years girl has been kidnapped since June 19, my lord. The police is not taking, despite my lord's direction, not taking adequate steps.
Where is Miss Patnaik today? She has come to the court.
In the principle, I'll take
No,
instruction.
this is not on board. That is the problem.
I'll take instruction. Give me the numbers. I inform.
Wait there. Let us try, bring the record. If you take up, you just on special notice list it.
Give the numbers so that I.
Restoration matter assigned to Honorable Justice Sri A.K. Mahapatra. Matter was listed since he was concerned. He has refused and it should be listed for the assignment.
Who passed the order? The dismissal?
The Honorable Chief Justice, the day when Honorable Chief Justice had passed the order.
Single bench matter?
Single bench. But Mr. Justice, Honorable Justice A.K. Mahapatra was concerned, therefore he recused from hearing the matter.
How this matter has gone to the Justice Mahapatra's court?
The restoration applications.
Single bench matter goes to him.
Yes.
There must be some civil matter. This is also hearing from civil matters.
But as per the design, go to the. We will be checking it, huh?
Oh, acha.
My read of the 948 of 23. Case of death of a minor schoolboy by electrocution. Case was listed for 31st 8 August, but not listed on
All
that.
right, we'll take up the matter. On 8th of August, it will come.
8th of September.
I don't know, 8th of September. 8, no, not 8. Make it 11th of September.
8th is
8th,
Friday.
Friday.
11. The report came in,
Yes. Yes, Mr. Tripathi.
Yes, my lord. This is a matter, my lord, wherein the advertisement was published by the Orissa Public Service Commission way back in the year 2019 and 20 for the post of Assistant Agricultural Engineer, Group B.
Yes.
The respondent applied for the said post, claimed that since he is visually impaired, so therefore he must be selected in that particular post, being a PWD candidate. Despite the fact that in the advertisement itself, when there is a functional classification,
Yes.
there was no mention of the visually impaired person to be appointed as against a assistant agricultural engineer post. But the London single judge,
Mr. Tripathi, whether the procedure has been followed, because
yes, procedure has been followed by law. Lots of minutes I'll take to Lordship.
in the Medical Council of India's case has given a guidelines how to exclude the post.
Yes,
There should be procedure that
yes, ma'am. That is followed. And one more aspect I wanted to bring to Lordship's notice. Lordship, the requisition authority, that is the state government, was not made a party in this case. But the direction was given that you select this particular person because in 2014 and 15 advertisement, you had advertised the said post for the visual impact. Those were not advertised in this 2019 and 20 advertisement. But since you had earlier advertised in 2014 and 15, therefore you give him a job, my lord. Lordship, kindly for a minute.
No, there is a point in that.
Yes.
It is a completely not a remote observation.
My lord, my lord.
Because earlier this post you yourself as earmarked for the visually challenged
My lord.
person, right?
My lord.
But this year you have excluded it. What is the basis of such a
My lord.
conclusion?
2013 and 14, as your Lordship knows.
No, because Mr. Tripathi, in between there is a 2015 Act has come into
My lord,
operation.
my lord. And 2015 Act, your Lordship knows, Section 32 of the PWD Act, which was there earlier, which was, my lord, given therein the identification of post and review of post in every 3 years.
That is why I'm asking you.
That is there.
Have you produced this all the records before the learned single
The
judge?
learned single judge, which are brought to the notice of the learned single judge that the GA department has given us this notification. As per the GA department notification, it has been excluded. That was brought. That has never been challenged there.
Notification is there.
Malad, I have not got it, but I have taken this plea also. But learned single judge has mentioned about it.
Just
Let me first take your Lordship straight away to the page 21, Lordship. Lordship, may kindly see, this is recruitment to the post of Assistant Agricultural Engineer Group B of Odisha Agriculture and Food Production Services under Agriculture and Farmers Empowerment Department.
Okay.
Lordship, may kindly come to the vacancy position. The Lordship got it, page 21. Lordship, may kindly come to that para 2, my lord, the vacancy position.
Just a minute.
It's 69 on the para.
The records are
Vacancy position.
মানে চেয়ারপাটা ରହିଯାଇଥିବ
Government of Odisha.
yes.
The category wise vacancy position along with the reservation thereof is given below. Now, Lordship may come to NB. Out of the vacancies mentioned above, 4 posts are reserved for ex-servicemen, 5 posts are reserved for persons with disabilities, and 1 post is reserved for sports person. Further, it is clarified that one leg affected, my lord, is because of the reason that, as your Lordship knows, that mobility, which is not restricted, that MNR, then PD, partially deaf, with suitable aid.
Yes.
Categories of disabled are suitable for the post of Assistant Agricultural Engineer. Physically handicapped person with disability of 1 leg affected, right or left, and partially deaf should be able to perform work by standing, walking, speaking, hearing, and lots of market, seeing which is required for the post of Assistant Agricultural Engineer.
Yes.
Only those persons with disability whose nature of disability is permanent, 40% and more shall be eligible to apply for the said post. Now, pursuant to this, my lord, the petitioner applied for the post, and after applying for the said post, since he was not being called for the viva post, he filed a writ application for this honorable court. And honorable court, by the interim order, asked him to appear before the committee, my lord. While the matter stood thus, he came before this honorable court and filed another application saying that already I have been allowed for the viva test. So therefore, this writ application has become infructuous. So honorable court observed, if it is infructuous, it is open for the OPSC to publish the result. It is open. The word was, it was open for the OPSC to publish the result. When OPSC did not publish the result, he came before this honorable court by filing another writ application.
Yes.
And in that writ application, my lord, the order impugned therein, Lordship may kindly come to the
Page 51.
page 65, my lord, that whole order, I'm not reading it out. 65, Lordship may mark it, my lord. Page 65. I don't want to trouble your Lordship taking this big order, my lord. From the pleadings, para 23.
Yes.
From the pleadings of the parties and also submission made by the Law and Counsel for the parties and the documents on record as detailed above, it is amply clear that the petitioner was eligible to apply for the post of Assistant Agricultural Engineer Group B in terms of the advertisement number 2 of 2019 and 20.
Mr. Tripathi. BP Tripathi, an additional government advocate.
Lordship, I am appearing as a standing counsel for the Odisha Public Service Commission.
Oh, yes.
Too many hats, my lord, therefore I am sometimes.
Standing counsel for the Orissa Public Service Commission. This intercourt appeal has been filed to challenge the order dated 1st May 2023, passed by the single judge in WPC number 10399 of 2020, Annexure 3 to the Memorandum of Appeal. Stop. Mr. Tripathi, known as standing counsel, has taken us to the relevant advertisement, being advertisement number 02 of 2019 and 20, Annexure 1 to the Memorandum of Appeal, and the RATHO with the following notes appended to the said advertisement. It is in the page number 21. NB colon. Out of vacancies mentioned above, comma, 4 in word then, posts are reserved for ex-servicemen, comma, 05 within bracket 01-W/5 posts are reserved for the PH within first bracket person with disabilities, and 101 within bracket word post is reserved for the sports persons. Subpara. Further, it is clarified that the one leg affected within bracket MNR, comma, PD with suitable 8 categories of disabled are suitable for the post of assistant agricultural engineer, comma, PH persons with disability
One leg affected, my lord.
one leg affected, then we get right or left, and partially deaf, then we get PD, should be able to perform the work by standing, walking, speaking, hearing, and seeing, which is required for the post of assistant agricultural engineer. Only those persons with disabilities whose nature of disability is permanent and is 40% and more shall be eligible to apply for the post. Stop. According to Mr. Tripathi, in my view of review, for the post of assistant agricultural engineer, the person with the disability within bracket visually challenged were excluded as seeing, quote unquote, is highly essential for discharging the duties of the assistant agriculture officer. According to Mr. Tripathi, Learned Standing Counsel, Learned Single Judge has taken into consideration the advertisement which were published earlier, meaning before the review was undertaken, and since in that advertisement the visually challenged persons were declared eligible subject to other qualifications for the appointment of assistant engineer agriculture, it has been directed by the impugned order that the writ petitioner respondent shall be appointed Mr. Tripathi Learned Council has also pointed to us that the Department of Agriculture, who is the appointing authority, has not been made party in the said writ petition. Therefore, the writ petition was suffering from the fatal defects in regard of in respect of arraignment. Having regard to the following observation of the learned single judge, we are of the view the matters required examination. Stop. Just quote this part. Para 23. Para 23 is the
Para 26 is the operative portion where it says 2014 and 15 notification you take into consideration.
oh, this 26. Para 26. Stop. Admit. Issue notice returnable on 19th October 2023. Steps for service of notice on the sole respondent shall be taken by the appellant within 3 working days from today by registered post to AD. Then go to the IA number 33474 of 2023. This is an application by the appellant paying the operation of the order dated 1st May of 2023 was by the learned single judge in WPC number 10399 of 2020, Annexure 3 to the memorandum of appeal. Issue notice returnable on 19th October 2023. Steps for the service of the notice be taken on the sole opposite party by the applicant to a registered post with AD within 3 working days from today. Stop. Meanwhile, the operation of the said judgment dated 1/5/2023, Annexure 3 to the memorandum of appeal shall remain suspended.
Deep to get full matter.
Item number 2.
Item number 2, file an application, interim application for bail. I'm permitted to withdraw mine.
What is your number? Can you just help us?
IA number 311 of 2020.
All right. You are Mr. Bhuiya.
Yes, madam.
I would do the Mr. L. Bhuiya Learned Council. That is this case number, no? Learned Council. That's 311 of 2022. Appealing for the applicant has submitted that he has instruction. That he has the instruction to not close this application as the appeal is ready for hearing. Stop. We do not find any impediment. Accordingly, this application stands disposed of as not placed. Memorandum in this regard is filed today in the process and taken on record. The council looking at the state. What is an additional government advocate? You are the standing council or government advocate?
Additional standing council.
Additional standing council appears for the state. Yes. Next. No, this is not our subject matter. That will go to some other. This in appeal, this counsel for the petitioner is given liberty to mention. That appeal you can mention when you're passing an order.
Item number 3.
Your Lordship,
Yes.
So order challenge against the single bench before entering into the area of the matter. The first of all, the petitioner has to remove the defects as pointed out by the stamp reporter. 5-1 as a 5-1 defect.
Defect is probably copy not served.
Copy not signed. Both of it are going to comply. Court of day and after make they come day after tomorrow.
Not tomorrow.
Tuesday is not possible. We posting it on.
You are not saying matter urgent nature, but some defect.
Just a Tuesday, huh? Let the matter be listed on Tuesday. They give the date only. Don't try Tuesday. Meanwhile, the defects is identified with the registry shall be removed. Mr. S. Jenna. Blood council has appeared for the appellant. Stop. He will peruse the records and find that earlier also the accommodation was made. There shall be no further accommodation for removing the defect. Mr. Rajesh, is telling also for the state. All right, you are also appearing there.
No, my lord.
No. Who is appearing in this matter? Anyway, it is not admitted. No mention. Score out the line.
Price. For the time, last week, pass on the
What? You just see the order. Last order is this is also is pointing
order
out.
dated 14/8/2023. You have nothing for the orders of this court.
You shall pass an order because now you have appeared, but you are seeking adjournment. Right, all right. Take the steps, otherwise you know what will be the consequence. You do not follow the steps. Yes. Next.
Item number 4, may please. The annex of 15,
Yes.
part page 1 and 4 of the petition that is under challenge, that is the expert order. And the registry of the Supreme Court has pointed out delay of 86 days. But my submission, there is no delay because we expert order in direction, in the expert order, it was directed to prepare an appeal. We received the appeal from the appellate authority respondent 2 on 24/5/2023, annex 14. And we preferred the petition on 8/6/2023. Within 15 days.
24/5.
24/5/2023. We received the notice from the respondent 2.
Under this writ appeal.
Writ appeal we preferred on 8/6/2023.
8/6.
Within 15 days of receipt from the notice from the appellate authority, we verified from the website, official website of the Supreme Court, and we prefer the petition. And in the meantime, we have also filed the certified copies.
Call it Mr. P.K. Tripathi. The council appealing for the petitioner has submitted that. There is a for the dispensation petition also you have filed.
Yes.
Subsequently, we filed the certified copy, Your Lordship. The dispensing with filing certified copy was filed, and subsequently we filed the certified copy. The noting is also there, Your Lordship. 21/7.
You also filed a petition for condoning the delay.
Miller.
So now you are saying there is no delay?
Because so far the registry pointed out that 86 days delay. Therefore, we filed this application.
All right. Just in RE number 3411 of 2023, there's an application of section 5 of the Limitation Act for condoning the appellant delay of 86 days in preferring the intercourt appeal from the order dated
P1/2023.
3/1 or 21/8/2018.
Annex 15 that is on challenge. 3/1/2023.
Come to your page number 2 below. Page number 2.
The annex 15, the page 2, the paragraph 5. The improving order under annex 15 was passed on 3/1/2023,
And the said order was passed at the press administration stage without issuing a notice to the applicant.
No, this part, this, just below this is the cost title, name of the party is just para 2 at the bottom, that is an N2. The matter of which present appeal arises was before the Honorable Court at the instance of the respondent number 1 in shape of such and such, disposed of the wide judgment dated 21/8/2018 under initial 8 and WPC number such and such disposed of ex parte 3/1/2023, which is the impugned order.
Impugned order annexure 15.
All right. From the order dated, because you have mentioned the annexure, also annexure 8 is the impugned order.
Annexure, in fact, annexure 8 is not the impugned order. Wrongly typed. The annexure 15 is the impugned order.
All right.
The certificate.
So this is the place only to give the order of reference, which is under challenge, not all other orders. 3/1/2023. Passed by the single just in WPC number 37002 of 2022. Stop. Heard Mr. P.K. Tripathi, learned counsel appearing for the applicant. Mr. Tripathi has clearly stated that the authenticated copy of the order was received by the appellant on 24th May 2023, and the writ appeal has been filed on 8/6/2023. So,
I mean, sorry.
hence there is no delay as such.
In fact, we received a notice from the appellate authority on 24/5/2023, and thereafter we filed writ appeal. It was directed in the annexure 15.
No, what kind of notice?
That it was directed by Lord Honorable Single Judge, allowing the respondent number 1 to prepare an appeal before the appellate authority under section 127 of the Illicit Act 2000.
Did not appear before the writ proceeding.
Expert order.
That we expect order.
The appellant gathered the knowledge of the ex parte order dated earlier date 3/7 on 24/5/2023, when a notice was served on them in respect of the outcome of the said writ petition, which was decided in absence of the appellant. Stop. According to Mr. Tripathi, there is no delay from the date of the knowledge of the said ex parte order. Stop. With it as it may, issue notice returnable on 4th of October 2023. Steps be taken by registered post with AD for service of notice on the opposite respondents.
One.
Only one was superintending engineer.
This is the appellate authority. Who has issued the notice of
Superintending engineer come electrical inspector.
electrical inspector.
To the opposite party number 1 within 3 working days from today. So let us come, because this is an explanation according to you. They have a right to challenge it. Take steps within 3 days. It will come on 4th of October.
Hi.
May I please, Your Lordship?
Yes.
Page 180, annexure 3, the impugned order.
But there is a delay.
That delay, Your Lordship, has condoned.
Oh, that's not.
That has condoned, and that dispensing it, there is also I have dispensing with Your Lordship granted us.
I remember now. Yes.
Also granted us 30-day time to file that judgment.
And this matter will be taken up for disposal today.
Yes, yes.
All right.
Your Lordship, may turn to page 180, madam.
What is your case that we can, this
My
respondent do not have this
Yes,
qualification?
ma'am. The very short point is involved in this case. He does not fulfill the requisite qualification as per the advertisement.
Okay.
That is the case only.
You are referring to 107.
My 180 annexure 3 the impugn judgment, my lord.
No, all right. What is the relevant paragraph?
My big judgments mean it starts from 42. I'll tell if your lordship can take it up on Monday, my lord, because I am suffering from throat infection. So that I'm not able to read 7-8 paragraphs.
Government advocate. Yes, Supreme.
I have to read at least 7-8 paragraphs.
Throat infection. Monday.
Monday at 2 o'clock, madam. Because we have been out of service, madam.
At 2 o'clock because it will take some time, my lord.
2 p.m. I don't know. There may be some other matters also.
It will come fast because it's the fast madam.
Mr. B.S. Patil, Solicitor is appeal for the respondent. You are appealing for all the respondents.
Yes.
Private. Yes. Next. This qualification issue means they are not having the B.Ed qualification.
Graduation, that degree.
The degree obtained from
That
from Bombay and Prachin Kala Kendra, Chandigarh.
that is a diploma. He has obtained a diploma that our requirement is degree. So that only very small point you will also have to go through that.
No, because you declared some of such diplomas in particular special as the degree, that will be the equivalent to degree.
Yes, ma'am. If that is equivalent, then that can be considered. But that equivalent, there was
Equivalent. So you come with that document, okay?
Yes. They are given upon.
perhaps he is not appealing for all the respondents. He is appealing for only respondent number 1 and 2, 3 and 4 are also university.
All right.
And 5.
I'm appealing for the private opposite party.
Yes, 1 and 2, and 5 is the performer party. That's it.
It will call. This corporate can you contact?
It I have contacted and I have sent a message. Still appear. So we see.
All right.
Item number 6.
May I please, Your Lordship?
Yes.
In this appeal, the order of the Honorable Single Judge under Annexure 1 is silent. Whereby, my lord, the Honorable Single Judge, during pendency of civil and criminal litigations among the trustees of a public charitable and educational trust, my lord, has permitted operation of the bank account in exercise of writ jurisdiction. Prior to taking your lordship to the impugned order,
Suit is pending.
so at that point of time, it was dismissed for default. Restoration application was filed, and on that ground, one of the trustees, the different respondent number 4, has approached the bank that since the suit has been dismissed, restoration application was pending. Allow me to operate. Bank did not. Bank said no, restoration application is pending. I will not allow. Hence, he has come up before this honorable court. This honorable court has passed the impugned order, has allowed him to operate. Now the suit in the meantime has been restored. And in other appeals also, my lord, orders have been passed that if any of the trustees has any requirement, then he can approach the district judge, the learned civil court, for release of funds, my lord. Those orders are now. That is why on yesterday, my lord, I said in view of this restoration of the suit, so now everything has to be decided in that suit, my lord. So, my lord,
Who is appearing for the trust?
but now the trustees are in dispute. The trust as such is
Regarding the constitution of the trust itself, there is.
trustees, yes. Among the trustees, allegation of mismanagement font, siphoning of fonts.
Why is the honorable and single judge?
Annexure 1, page 36. Page 39, paragraph 2, my lord. My place. He submits resistance against operation of the three accounts by his client is from the interveners whose stood dismissed for default on 3rd of December 2021. It appears interveners, the present appellant, my lord, have applied for restoration of the suit, and notice was issued to the bank, who by impugned letter dated 27th December 2021 said that in view of the notice for restoration of suit, the case had not been dismissed. He proceeds to demonstrate that the claim number 1 in the suit was in respect of erroneously numbered account against which his client is not pressing for relief. None of the other 3 accounts mentioned in prayer 5 are subject matter of the suit, dismissed for default and as yet not restored. He submits that the bank has taken position to abide by order to be made by this court. Thereafter, noting down the contentions of other parties, my lord, the Honorable Single Judge has given the reasoning at paragraph 7, page 41. May I please, my lord? Paragraph 7. Upon hearing submissions of parties, court is of the view that prayer made in the petition is required to be allowed. This is because the interveners have sought for inquiry on accounts of the trust. Specific claim in the plaint is in respect of mentioned accounts, which are separate from the 3 accounts mentioned in prayer 5 in the writ petition. However, interest of the interveners need also be protected. The interveners and other trustees are added as party. Petitioner will file consolidated cause title, IN number so and so is allowed, disposed of. Now that all the trustees are parties to the writ petition, further directions are being made. There will be order in terms of prayer 5 in the writ petition in respect of those accounts except erroneously mentioned account number so and so. Petitioner is required to obtain and furnish quarterly statement of accounts in respect of the 3 accounts to be operated pursuant to this order to added opposite parties. Continuance, termination or otherwise of this order will be subject to final order made in the suit of the interveners being OS number so and so pending in the court of so and so. Well, just to give a brief on this.
Who is appearing for the respondent? Anybody is appearing for the respondent?
Yes. I am appearing for the respondent number 6, and my learned senior is appearing for some of the respondents.
That means I am also appealing for respondent number 5. It seems that my learned friend has submitted a miscase, filed a miscase. No, my lord, I have not filed a miscase. Yesterday I have not filed. No.
There are some pending cases.
He has filed a miscase long back, my lord, and my lord has called for replies. Replies has not been filed.
He has filed a miscase for appointment of receiver. I don't think that he's pressing that application.
I have not filed up.
No, I was actually facing that
Yes. So it's
in order to be vacated.
all of us are correct. All of us proceeding in the premises that he is not pressing that idea.
That is what.
Correct.
And he's only saying that the order is not unsustainable, so the bank, this operation that has been there, the entire issue to be taken by the civil court, not here.
That's the point. Now that the suit is already restored, and because it's as my learned friend is saying, that's a public trust. It's not a public trust. The trust deed is available with me. It's a charitable trust among the family members. It's not a public trust. There's a distinction between a public charitable trust and a trust. So they are asking rendition of account in respect of that particular account, which is excluded by the Honorable Single Judge. The rest of the 3 accounts are institutions which are offshoots of the trust. Institutions offshoots of the trust. Those are all educational institutions they are running. In case any problem with regard to freezing account, non-dispersal, they will affect the students and institutions at large. So keeping that in view, this interim protection has been given. This is just interim protection. So writ appeal, to what extent it's maintainable, that is also an aspect to be examined, but without going into those aspects. But if they have any grievance, now that the liberty is granted by the Honorable Single Judge, they can approach the court where the suit is pending.
And in that event also that you have to explain this order. We have to say this order is not of the permanent nature.
Definitely.
It is a temporary nature.
Definitely.
Yes.
Yes, definitely, ma'am. Sir, I can add something here. Sir, whatever it was submitted by my learned friend, that this particular account which has been allowed to operate, it has nothing to do with the subject matter of the suit. So far, the account which is the subject matter of the suit, my learned friend's client had moved an application in the civil court for allowing him to operate that account that has been rejected by the trial court. He preferred an appeal here that has been dismissed. That is part of the records. I produce that. So far as his prayer to operate the account, which is the subject matter of the suit, has been already rejected. Now his attempt is the particular account, which is not the subject matter of this suit, that should not be allowed by anybody to operate, so that the account, the institution must be closed. That is what the entire attempt is. Now the Honorable Single Judge has said, so far as that account is concerned, since it is not the subject matter, and the ultimate prayer relief for you are made in the suit for rendition of account, so far the trust is concerned. Therefore, the Honorable Single Judge has directed that is subject matter, that will be subject to the outcome of the writ application, and you can submit the accounts and other things. That is also direction. But so far this particular account, you also kindly see
No, not writ application. He says they are made, will be subject to the final order made in the suit.
Yes, sir. So it's not, it's not an interim order. Sir, paragraph 9. Sir, paragraph 9.
I'm reading only paragraph 9.
Yes, page 32.
Yes.
There will be order in terms of the prayer number 5 in the writ petition in respect of those accounts, except erroneously mentioned account, which was a typographical error that has been excluded. Petitioner is required to obtain and furnish quarterly statement of accounts in respect of 3 accounts to be operated pursuant to this order to added opposite parties. Continuance, termination, or otherwise of this order will be subject to the final order made in the suit of the interveners, being OS number 13 of 2016. Intervener is the 20 in that suit. Yes. That account, the account which my learned friend now claimed, that was not the subject matter of the suit. But that said, because it is the restoration application is pending between the parties, therefore he did not allow to operate the account, for which the cause of action arose for the trustee to come to your lordship, and your lordship passed this, the Honorable Single Judge has passed this order. And if you also will look to that is a part of that, so look his application for operation of the account in respect of the suit accounts, that has been rejected already. That is a part of it. Ma'am, aji joda di, ami joda doche.
Calling se order to the
Yes, give it. That is part of the records. Yes.
In fact, yesterday, which my learned senior is referring to that order, I have given that order.
That is something different, sir. My learned friend has filed a memo yesterday. That is an order arising out of application for restoration.
No.
That all 3 orders. Yes. One, Mr. Mahapatra was appealing account. That is independent account.
Then I'm not saying that order I have filed. Let me check.
That was an application arising out of an injunction signed by will, and the Honorable Single Judge said that has become infructuous, and that is in respect of another account. It has nothing to do with
all these account matters involved in this writ petition and writ appeal matter. These are separate.
Totally separate, sir.
Completely separate. It's not a part of the matter suit prayer and all this.
You also look to, I have given that copy of the affidavit which was formed part of the writ application. I have given the order which was passed at his instance. You also look to that. I have given to her. Page number 5. Sudhakar Pati is his client with the appellant here.
Yes.
You also look for the page 1 and page 6. Instant petition dated 9/1/2018 is moved by the plaintiff seeking an order from the court to permit the trust, he claimed to be the trust, to operate his bank account number so and so. The last number is 760, which is the subject matter of the suit. Mention with defend number 6 pursuant to the board resolution dated so and so, which is absolutely necessary to meet. That is his allegation. So look to the operative portion of that order by the trial court. That is at page 4, page 8, running page 8, internal page 4. Sir, I am reading towards the bottom. That apart, I am reading just 7 lines from the bottom. That apart, in absence of any evidence regarding the difficulty being faced by the trust, the court is of the considered opinion there is no need of any interim order being passed to deal with any particular account maintained with refer number 6. Any such decision without any evidence or record as to the difficulty in running the trust due to want of fund would complicate the situation and unnecessarily interfere in the management of the trust. For reason herein above, the court is of the conclusion that the plaintiff, in absence of a clear case being made out for interim intervention, should not be permitted to operate a specific account lying with the number 6. This order he again challenged before this honorable court, that is at page 12, page 13, that has been dismissed. Hearing the submission, kindly look to that. Page 13. Hearing the submission of the counsel for the petition, perusing the reasons assigned in the interim order, this court finds no scope to interfere in the interim order. However, considering the pendants of the suit creates impediment in the transaction of the accounts of the petitioner, this court directs the district to conclude the proceeding in CS number so and so within the period of 9 months from the date of so and so. So that was in respect of the suit account, which was the subject matter of suit. My friend wanted to operate that account, claiming that I am the trust, I am the chairman of the trust. So that has been already rejected and appeal has already dismissed. Now, so far as this account is concerned, which is the subject matter, which is the single judge has dealt with, that is not the subject matter of the suit. That is why, honorable single judge again also look to the order and specifically said in paragraph 2. It's a left-hand place here. Yes. If you also look to the, if you also kindly come to the REIT application that must be available before also that the REIT application at page 61. The plaint has been annexed. Plaint. Precisely, which is the subject matter of the suit. Yes. Page 61, para 34. Let a decree declaring a sum of rupees 3 crores transferred and such in account number, last number is 9648 of State Bank of India, Bhubaneswar, main branch, Bhubaneswar, in the name of Means Mental Trust from current account number so and so, the Punjab National Bank, Station Square branch, Bhubaneswar, be declared to be the property of Natural Resource Trust. This is not the account in the present dispute period. And what the honorable single judge are dealt with in paragraph 7, paragraph 3. Because the argument was advanced before the honorable single judge, because of this paragraph 3 in the suit, let a decree directing inquiry into the accounts of Natural Mission Trust by an independent auditor to be appointed by the court for the current financial year 2016-17, as well as the past 3 financial year 13-14, 14-15. These, taking into consideration this prayer, the honorable single judge has directed in paragraph 7 that will be, the accounts will be submitted by the opposite part respondents, and that will quarterly basis, and that will be subject to the scrutiny, and that will be outcome of the suit. And as my lord rightly pointed out, this is an interim arrangement. It is an interim arrangement for the functioning of the institutions. So against an interim arrangement, how appeal can be enforceable, that is also another point you also can examine.
All right.
Now, 3 points have been raised by my learned seniors. First is, it's not a public trust, it's a private trust among the. Second is, the order that has been passed by the honorable single judge is only in respect of accounts which are not subject matter of the suit. Second. Third is, the order passed by the honorable single judge is in the nature of an interim order, hence no writ appeal maintainable. Now, as regards the first point, my lord, that it's not a public charitable trust. The difference between a public charitable trust and private is the beneficiaries are identifiable or not. It's not that whether any public funds is being invested or not. If the beneficiaries are unidentifiable, it's a public trust. The trust deeds are on record, my lord. The beneficiaries are the poor, the marginalized, and
Last, not individuals.
exactly, my lord. So it's a public trust,
Yes.
undisputedly, my lord. Now, second is, I'll come to that accounts part last. The second is the order passed by the honorable single judge is in the nature of an interim order. My lord, I've seen that the honorable single judge has allowed operation of the bank account and has said that any variation is subject to final order in the suit. So he has sealed the matter till disposal of my civil suit. So it's not a interim nature.
But
It's not in restoration of suit.
All right, but the writ petition has been disposed of.
Disposed of.
So what the writ petition is concerned, it is the final.
Final order, exactly, my lord. Bow down, my lord. Now, regarding that, accounts are different, my lord. My lord, kindly see the plaint. The plaint has to be seen in its totality, my lord, not the prayer only. My lord, kindly turn to the plaint, which is annexed in the writ petition, that starts from page 51 in the writ petition, my lord, before the Honorable Single Judge. My lord, may come to page 54, paragraph 11. Page 54, paragraph 11 of the plaint, my lord. May I place that the trust has been maintaining its accounts with the Punjab National Bank Station Square branch, Bhubaneswar, wide account number so and so. These are the three accounts which are the for which the Honorable Single Judge is allowed operation. Now, my lord, kindly to further amendments in the
54 is an extract of the resolution.
page 54 in the writ petition, my lord.
Okay.
Page 54 in the plaint has been annexed under Annex 3. It starts from page 51 in the writ petition. I am drawing your lordship's kind attention to paragraph 11, which is at page 54.
Yes.
In paragraph 11, accounts number of the trust are mentioned. And these are the accounts in respect of which Honorable Single Judge has allowed operations. Now, kindly see the further amendments in the plaint. My lord, may turn to paragraph 26. That is at page 59. I will place only paragraph 26, 27 and 29 in order to drive the point, my lord, that the allegation is the auditors of the trust, the erstwhile chairman who has misguided and filed as if he is the chairman before the Honorable Single Judge. He, along with the auditor of the trust, they were hand in gloves. They have mismanaged the trust funds. We found out that one of the transactions he has made is that in respect of paragraph prayer number 1, 3 crore he has liquidated FD and transferred. One of the transactions, my lord. In respect of other transactions, paragraph 26 and 27, 29, your lordship will read, my lord. Amendments have been made that there has been also mismanagement in respect of other transactions which will come to light once an inquiry is made into the my lord, transactions by a proper authority. And that is why the prayer in that prayer 5, my lord, can let a decree directing inquiry into the accounts. So can it be said that the plaint is only limited to prayer number 1 in respect of one account? When the allegations are that there are many other, these are the other accounts of the trust, and in respect of those accounts also there has been mismanagement which will only come to light only if an inquiry is made by the proper authority, my lord. So it's not a fact that only one account is involved in the plaint. All the accounts of the trust are involved, my lord. Then now, my lord, as regards the challenge to the order of the Honorable Single Judge, my lord, is the respondent number 4. He has filed the writ petition before the Honorable Single Judge, representing himself as the chairman of the trust. The suit was, now kindly see, the trustees are in bitter litigation, civil and criminal. That respondent number 4, who is the erstwhile chairman, 407 to 420, affairs are pending. Criminal investigation is pending. Now, when all these litigations are pending, he represents himself as the chairman, files a writ application in the name of the trust without making any of the trustees as parties and only the bank that allow me to operate. When we come to know, we file an intervention application that we are also necessary parties. The Honorable Single Judge, my lord, the day when our intervention application was allowed and the writ petitioner was directed to file a consolidated cause title, on that very same day the writ petition has been disposed of. So we have no opportunity to bring on record that this man is an interloper who is no more the chairman of the trust. Trust resolutions are annexed. I have annexed writ appeal those trust resolutions. And the client of my learned senior, Mr. Ratho, my lord, he is also signatory to that resolution where this person, respondent number 12, has been removed from chairmanship and one of the appellants has been appointed. The order which my learned senior, Mr. Rautra has referred to, that order, my lord, arose when one of the appellants has become the chairman. We filed an application before the civil court that now we have become the chairman. Let us be allowed to operate the bank accounts. The Honorable Civil Court, the learned civil court held that no, since all these matters are pending final adjudication, I will not allow anybody. The bank has put a debit freeze that I will only allow deposit, no withdrawal. Now that situation is continuing since 2016 up to now, madam. And when those orders, when we filed the application that let us be allowed, civil court rejected. When they filed similar applications, that also learned civil court rejected. Now those, my lord, orders have been subject matter of order 43 rule 1 appeal here before this honorable court, which have been disposed of, saying if the trust has any requirement, you file appropriate application before the civil judge.
Yes.
Now, as on date, no application has been filed by them before the in the civil court that these are the requirements. In spite,
Because of this order only.
no, my lord, prior to this, and just before the honorable single judge order also, those liberties were granted in the order 43-1 appeal before this honorable court. They have not against that. But we have, in fact, I have filed interim applications here that now kindly see this is a trust registered order 12A registration was also there. That has expired, my lord. He is not bothered to cooperate with us in applying for its renewal. My lord knows without a 12A registration, the consequence thereof. Now all the incomes will be taxed. This trust will be without funds and it has to be closed. Now he is not cooperating in that renewal, my lord. He is only interested for operation of the bank accounts. Without making the trustee as party, he himself misrepresenting himself as the chairman, he has filed that application. And when we approach filing an intervention application, my lord, at least we should have been given an opportunity to demonstrate all this, my lord. And this finding that the other accounts are not subject matter of the plain text, my lord, I would submit it's an error of my lord record.
Mr. Roth, what I think that will interfere partly that order and remitting the matter back to the learned civil just to give them the opportunity as the intervener to place all the records before him. But no, till then this interim protection that was given, that will continue. Till then it will continue. But there will be the liberty to approach the learned civil judge also to vacate the said order. We are not passing because we'll be then also the guilty of the same thing that you had not filed anything. But parallelly that in the civil court your prayer has been rejected for trying to operate this bank. This is
my application has been rejected. There also similar application has been rejected.
That's why also subsequent acts for now to adjudicating the matter afresh. So we are remitting the matter to the learned civil judge.
I would, my lord, abide by that, my lord. Subject to my lord, I have one submission. Now, in view of the fact that at that point of time the suit was not there, restoration application was pending. Now the suit has been restored. Now orders have been passed in 43-1 appeal that if you have any requirement, if any person has a requirement, trust has any
You are not taking any comment, I am telling you.
But now in view of the pendency of the suit and that's now has,
whether these are on record, these amendments that you are now taking before us, whether these amendments are on record.
Let me tell one more thing.
all the facts, my lord, what I have submitted is record. My lord, not a single fact I am telling on the record.
Record he said that affairs are pending. He misled them.
No, that I agree to
Charge final has been submitted. Trial court has accepted there is no case against us, and he has also failed to submit a protest report. Kindly see these orders. He is suppressing these facts.
Just a minute. In an appeal, because you said that as an intervener, I was not given any opportunity to file the records to make the submission.
Sir, 1 minute, sir.
My lord, my lord, not like let's say, but I am trying to make learned senior. 1 second, sir. My learned senior has said that I have misrepresented this honorable court that the criminal case is pending in view of this final report. My lord, my learned senior has very conveniently avoided the order passed by this honorable court in share LMC, quashing that order that you could not have accepted that final report. That order is there, my lord. This honorable court is passed.
There was no notice to you.
No notice, that is what, yes, my lord. That is why this honorable court is passed that.
Kindly see that.
Well, these High Court order.
Yes.
Wrong or right, there is a High Court order.
Yes. So now it is back to that stage. It's not passed, my lord. No final report has been accepted.
We don't know about that.
I think it's not supposed to be noticed at this stage.
It has not been noticed there.
Not because
Supposed to be noticed.
accused is not required to notice. Someone is issued. That's the second.
You should not it to our notice.
You have no right to appeal. Someone is issued. Why is the right of the accused to know about the
That's right. You should serve the copy to us in advance if you are aware about this fact.
since accusation has been
And producing it directly. You should serve the copy.
May be permitted.
No, these are the matter issue, Mr. Roth. Issue is very limited in this.
sir. Yes,
MC only because of acceptance without notice to the informant.
That is there. They were given opportunity to file protest petition. 1 second. Kindly see that order passed by the land trial court, my lord. They were giving 3 opportunities to file protest petition. They did not file it. That is what the order was.
that's
1 second, Mr.
in view of this order.
I'm reading out the part. On pages of the order sheets of the learned court below in CT case number such and such, it has appeared that the petitioner, after appearing, applied for time to file the objection to the report, and it was allowed twice, and finally, on the date fixed on such and such, the final report said to have been accepted, as there was no step from the side of the petitioner.
Correct.
Yes. Thereafter, it has been observed whatever the such and such report relevant provisions to comply such and such with obligates that officer in charge to communicate the actions taken by him and report and forward to the magistrate under subsections 2-3 thereof. It is also statutory provision that the court is to summon the informant accompanied by with a copy of the final order report in order to receive response from him. It appears thereafter, neither the local police station has informed and supplied a copy of the final report to the petitioner, nor the learned court below. Rather, the petitioner made an attempt to obtain a certified copy thereof, but before he could obtain, the learned court below closed the proceeding on the premise that there is no step from the side, his side. So they have intervened.
Yes, my lord.
So whatever we decided.
No problem. In fact, we did not know about that order. That's the reason I could not say about that order. That could have been brought to our notice, sir. We could have served us a copy about that order before filing it before my lord.
This order has been passed by the.
That is passed on their application. We do not know about that order. Now he is straightway producing it, saying that we have suppressed it. It can't be made like that.
Accusation against me, that
is in that proceeding, no? Accused person was not a proof in that part.
No.
How that petition was maintainable?
Accused doesn't have a right to all these right to issuance of someone.
That case you have referred.
That refers to without supplying the column of the final report, issuing a summon for the protest, my lord. So final report was not submitted.
No, you know that the charge sheet, the final report was accepted.
No, my lord. So only I have
you have challenged that order.
Someone without the final report. So how can I make a protest petition on what basis, my lord?
I understand, but just also appreciate the another part of this. With the acceptance of the final report, terminating the investigation, the accused person acquires a right, wrong or right, or that is an issue. He might have joined that issue that he was not aware when the petition was taken. Suppose something is accepted. And accused is just exonerated of all the allegations. He has acquired a new status. And by this order, that status might have been affected.
Actually, I'm not on. Yes, my lord.
That you should have done. But anyway, the order is passed.
They have not challenged it, my lord.
Whether they will challenge that order or not.
But in any view of the matter, can I submit, Lord? But all that appears, Lord, my learned friend is arguing the whole suit before my Lord's Lord. That's not the. This is an appeal arising out of the honorable single judge order. Now, your lordship is the continuation of the honorable single judge proceeding. Instead of relegating the matter back to further complicated, why not to finally decide it here and dispose of it?
He is also asking for that.
Right, my lord. Right, my lord. Why to
Just add. My infant said that the honorable single judge on the very same day allowed the application for intervention without giving any opportunity to dispose of the matters. You also look to the their application on 25/4/2000.
Not show me the order. Whether they have been given any chance or not.
Yes, sir. You must look to that. They've argued. You must look to all the documents that produced before the honorable single judge. You also look to the impugned order. You also look to the order sheet also. This matter has been argued time and again. And the honorable single judge. You also look to Mr. Nanda's argument. The senior counsel had appeared.
Yes.
Also paragraph 4. Mr. Nanda and senior advocate appears on behalf of the interveners. He draws our attention to the plain number 3 of the plaint it is reproduced here and there. Then page 41. He submits all account of the trust and subject matter of the suit. He relies upon the judgment dated 1st October 2021 of the Supreme Court in civil appeal number so paragraph so. He further submits in similar fact and situations where appeal under section 37 of the Arbitration and Conciliation Act was dismissed for default and restoration application duly made within the prescribed time that was attempt by the operational creditor to seek insolvency resolution. The court declared that there was a prayer for restoration was pending consideration. It has no hesitation in saying that in such a case, without a final decision on the prayer for restoration, insolvency proceeding at instance of the operational creditor cannot put into operation. He submit in any event repetition is not maintainable. He argued in detail, sir. And if you also look to their application, they have produced all the documents. That the order was passed on. So especially when the judgment was passed, impugned judgment was passed on 7th September 2022, and they produced 11/4 or 25/4/2022. They produced all the records along with their applications, and the matter was argued time and again.
They have appeared on 11/4.
And they had appeared on 11/4. Now my friend wants to say that we did not get the opportunity on the same day it was disposed of.
May I reply to that? May I kindly see the impugned order, page 42.
Now, what is the principal ground? Because he says you are not given any opportunity.
Yes, my lord. On that I am submitting. My lord, prior to all that I was submitting. I am a necessary party to kindly allow me to file a reply counter at least, my lord. So page 42 is the impugned order. The honorable single judge has allowed my IA, directed them to file a consolidated petition, consolidated cause title. So on that very day my IA was allowed. So am I not entitled to file a counter affidavit, my lord?
So you've been implemented as a party there.
On that day, my lord. On that day, my IA for intervention was allowed. Am I not entitled to file a counter affidavit, my lord?
No, don't confuse me. Don't say the implement and intervention is two different things. And two different sets of rights will come to you. If you are intervener, your right is very limited. Even the filing of the counter affidavit may not be your right.
No, my lord. On that day, can you see page 42 of the impugned order, my lord? Page 42. Of the
the intervention will be permitted to file.
Allowed.
Subject to the leave from the court only.
Yes, my lord. Page 42, kindly see.
Page 42
of the writ appeal.
These
order of the honorable.
Part of the order.
Yes, my lord. Paragraph 8. The interveners and other trustees are added as party. Full stop. The petitioner will file consolidated cause title. Full stop. IA number 5507. That's an IA for intervention. Is allowed and disposed of. Now that all the trustees are parties to the writ petition, further directions are being made.
This is apparent on the face of that. This is someone is included on the same date the writ petition was disposed of.
Correct. Let him argue on merits here also. Instead of
not filed the counter affidavit.
Sir, this is, in fact, if you actually look to that intervention.
When he has been included as a party respondent.
Sir, they have, in fact, practically, they have, in fact, argued the matter as interveners time and again.
On the
that is right. But this order says that they have made the party. So
that date it was said that it is made parties that but argument was advanced time and again.
Argument on the question of whether I am required to be given an opportunity, my lord.
So far as the
let them, whatever argument they could have advanced before the honorable single judge, let them argue, also fix a date and the matter can be.
No. They want to file the counter affidavit. Counter affidavit is not only the government's, also the records they can file.
Well, whatever argument they have advanced, they have advanced in the application.
Maybe true, but this is the very inconsistent order then. One year entertaining his status is the internet.
Kindly send it to the interim arguments.
And will be given liberty to file
Passed by this honorable court in the
for the time being, and you will be given the liberty to file a fresh application seeking vacation of the interim order. Because
my lord is referring to which interim order? My lord is referring.
This is the final order that is this order that is interim protection in 3 accounts.
Then my lord, one submission.
Yes.
Is by this order, my lord, the petition, the respondent number 4 has been allowed to operate the account.
Yes.
Has been allowed, my lord.
Yes.
We file an application.
My lord, my submission is that if he is allowed to operate for 1 day also, there is, my lord, because since 2013, Ali
will not operate
since 2016, my lord, the aspect can not be allowed to operate. Sir, the gap period on the passed the order, I filed the writ appeal and got a stay. Just 7 days operated.
Such kind of wrong submissions is not
application.
What is his admission? Making such kind of wrong submissions in the para 11, which my lord can just read one line and left out the other lines. Kindly see. Whether of the writ application, page 54, or I will give it for my lord's convenience. That is the writ application. Kindly see. He made admission, madam, before the civil court. We have only one copy. Kindly, my lord, I am giving you. Kindly see. Para 11.
Again,
Sir, this is in the
Mr. Pari, you have understood your difficulty.
Trust has been maintaining its account in Punjab National Bank, Station Square, branch, Bhubaneswar, by the account numbers also, which is not this, according to us, not the subject matter of the suit. All these bank accounts are being operated on behalf of the trust by the since its opening.
so, my lord, I am submitting.
Since its opening.
May I read it, my lord? I have said, since the date of filing of this plaint, the bank has put a debit freeze. Every time of the plaint, my lord, they up to 2016, they are now operating now. Speak, my lord.
Yes.
16 when they filed this plaint, the bank has put a debit freeze and has not allowed a single person to operate till 2023. Only the gap period, honorable single judge passed the order. I filed a writ appeal that 7-8 days they had operated. Not since 2016. Issues and so a single transaction certificate.
Now, what happened in the suit? Because that operation was stopped by the bank in view of the order in the suit.
No order, pendency of the suit.
Pendency of the suit.
See, and criminal case. Civil and criminal case is pending. So I will only allow my deposit, not the withdrawal.
So how the court can intervene that? Because it is the bank's own satisfaction, they will not operate.
Exactly, my lord.
Satisfaction, they will operate, and satisfaction comes from this order of this court.
Yes, my lord.
Right?
Yes.
So what I am proposing, try to understand that you file an application, whether the learned single, that is the learned single judge order, we are granting you the leave. That please vacate this order, otherwise this damage will or the danger will happen. If you go there, because this all the facts are here and scattered there.
My lord, I would submit this is the final relief in the writ application. So, my lord, if it would have been till restoration is filed, then things would have been. So, this order is the final order paid for the writ application.
We are making it as an interim order.
Yes. He is not trying to.
I don't understand. By our order, we will make it as an interim order passed by this party.
My apprehension is that by this, they will get the operation of the bank account, which my lord, which will put the trust in.
Today we are passing order Monday to the court.
So, my lord has protected me since the filing of the writ appeal that order be stayed. My lord, now that let that order continue. Let me fight the litigation.
Because we cannot come in conflict with the order passed by the civil court in such fashion.
Yes, my lord.
We cannot do that.
Then my lord,
You filed an application there in the, after the restoration of the suit, you filed the operation against them.
no, my lord.
That is
My lord. You not said 2016, my lord. After restoration, no applications have been filed. Let me make it clear. This is not a fact. 2016, at the time of filing of the plaint, I have filed an application which my lord is in the soul.
Who stops you from
But
filing?
now it's who stops me from. So it's wrong fact that after restoration, any application has been filed. After filing of the plaint in 2016,
all right. How much time will it take to file the counter affidavit?
my lord, as soon as possible.
No, this is a note. Use the web term.
My lord,
I want the days.
10 days, my lord. Within 10 days, I can file.
Filed by the next Friday,
Yes, my lord.
right?
Mm.
All right. So he'll file by the next Friday. Till then, you don't operate. If you do not file the counter affidavit by the next Friday, it will be this. We are marking it. This order will be automatically restored. For the time being, you're suspending this order. File by Friday next, and you can also then state before, because it is a trust property. That is why only for a few days that will be there. It's always Mr. Pari.
Subject to if my lords accept. We think I can make a prayer. Lord, what is the order passed by the Honorable Single Judge? Kindly see, madam.
Given the blanket of authority till the suit is disposed
No,
of.
Lord. We are allowed to operate. We'll furnish them accounts every quarterly. That's a condition attached.
All right. So,
My lord, so it's not that they are not posted with the accounts of operation.
no, that is there. But
So your lordship, I kindly appreciate, my lord. It's institutions, much important institutions running on the basis of these accounts. But what he wants is to stop and close down all the institutions acting contrary to the trust interest itself. No trustee is permitted to act contrary to the trust interest. That's the statutory provision in the Trust Act.
yes, obviously, because they are questioning the constitution of the
So
trust.
that what he is doing. Look, from this intention, your lordship, kindly see, my lord, what is the intention behind? The intention is acting contrary to the trust interest. My lords, keeping that in view, my humble prayer before your lordship is, my lord, lordship may make that order passed by the Honorable Single Judge interim. My lord, till at least for every 10 days, your lordship may target the matter to be disposed of. We don't mind, my lord, because trust cannot be affected. Public, the whole entire system is being affected, man. Kindly appreciate, man.
May my lord propose one thing.
And in fact, Lord, if you also look to the paragraph 6 of the impugn order of the single judge,
Yes.
why they have allowed, why the Honorable Single Judge allowed also kindly paragraph 6, because of the interest of the institution. Mr. Rautra replied by drawing attention to annexure 9. That's come to page 41, the writ appeal. That is the impugn judgment. Mr. Rautra replies by drawing attention to annexure 9 in the writ petition, being letter dated 18th January 2022 from Utkal University to the institute run by the to function. He submits further. The interveners themselves did not file the suit in the name of all the trustees. Mr. Nanda submits all trustees have been implicated as dependents. So now, because of the Utkal University said that unless you deposit that amount, the affiliation will withdraw. And every day the institution are facing problems because of the non-functional of this particular accounts. That is the problem. But Mr. Ratha said, in fact, in the absence, they don't want that this should run, the institution should run. This should be closed.
My lord, I have two submissions to mine. First is, in spite of repeated, my lord, liberty being granted by this honorable court in order 43-1, that if you have any trustee have any requirement, you please file an application before the civil court. As on date, not a single application has been filed by them who are so much concerned for the trust that we require for this purpose. That's in fact, my lord, on record. Now, on the last, in the, my lord,
Why they should file the application, Mr. Why?
if they require
The London Single Judge has given them liberty to operate the bank.
my lord, post honorable single judge and not pre-honorable single judge, they have not. So now they are saying the trust has a requirement. Now, this honorable single judge has passed the order in 2022. Since 2016, for the 6 years, the trust account was put on a debit phase. Trust has no requirement then, my lord. One question. Second, my lord, I am saying, don't listen. My lord, I am proposing one thing. Let a third person be appointed to operate the bank account.
And this honorable court has also gone through that.
Because we are giving you some liberty, that doesn't mean that all of a sudden apprehension should come. The order was passed on 7th September 2022. We are almost in another September.
No, my lord, that has been stayed immediately.
No, it was immediately stayed. When it was stayed?
About 20 days thereafter.
After the operation.
Okay.
About 20 days. So they have got a chance to operate about 7 to 8 days. My lord, so my lord, my apprehension is one, my lord, this honorable court in the writ appeal has also on the last occasion proposed.
Just without complicating the matters further, Mr. Roth, what I propose, give him the 7 days time to file the counter affidavit. And if you file the rejoinder as the petitioner, you file within next 7 days, right? And during this fortnight, this interim order passed in by the division bench will continue. And thereafter, the learned single judge will take the decision whether such interim order will continue or not.
Also give us a liberty, my lord. In that case, give us a liberty that we'll also immediately approach the honorable judge
Yes.
to operate the account in case there is an urgency. That liberty we also granted. That liberty we granted.
That is why.
Yes.
Only 15 days there will be.
That process continue, but with a liberty in our favor. With a liberty in our favor, we'll approach in case of any requirement of review.
Not in case during the 15 days, not for any reason it is continued further.
During that period, because there may be any urgency. He can't say everything.
No, just all right. That we are passing the order now. Yes. Heard Mr. S.S. Paril and counsel appearing for the appellants. Also heard Mr. B. Rautre, senior counsel, estate by Mr. S. Shekhar.
Yes, Shekhar.
S. Shekhar, learned counsel for the opposite party number. You are for opposite party number?
My learned senior for us, OP 4.
Opposite party number 4.
Respondent number 4, sir.
Respondent number 4. And Mr. P.K. Roth, learned senior counsel, estate by
Adhiraj Behera.
Mr. Adhiraj Behera, learned counsel, appearing for, you are appearing for the
Respondent number 6.
respondent number 6. Who is appearing for the banks? Mr. G.D. Call and counsel appears for the respondents number 1, 2, 3. 1, 2, and 3. 1, 2, and 3. And none appears for the respondent number 5.
My lord, I am on behalf of Mr. Danand Mahapatra, counsel for respondent number 5.
All right. What is your good name, sir?
Mr. S.K. Raut.
Mr. S.K. Raut and counsel appears for the respondent number 5 on instruction of Mr. Danand Mahapatra and counsel. Stop. By means of this writ appeal, order dated 7th September 2022, passed on single judge in WPC number 2372 of 2022, has been challenged. Stop. Learn a single judge by the said order has passed the following final order, has passed the learned single judge has passed the said final order, observing that there will be order in terms of prayer within bracket Roman 5 in the writ petition in respect of those accounts, except erroneously mentioned account number 055 3002 110 0025 Stop. The petition is required to obtain and furnish quarterly statement of the accounts in respect of the 3 accounts to be operated pursuant to this order to added opposite parties Stop. Continuous termination or otherwise of the order will be subject to the final order made in the suit of the interveners, being OS number 13 of 2016, within brackets Sri Shakar Poti and others versus Sri Damodar Poti and others, close the bracket, pending in the court of the district judge Khurda at Bhubaneswar. Stop. This is an admitted position that at one point of time, the above referred civil suit was dismissed, and later on that was also restored in the same file. Stop. The said suit was the intertrust dispute. Stop. What suit is on intertrust dispute, and it is pending since 2016. Stop. The trust is managing the schools or what?
Running a physiotherapy college.
Running a institution. Running a educational institution. It is running an educational institution, running educational institutions. And as such, the trust has to defray different expenses on daily basis. Stop. On that ground, the writ petition was filed by the trust called Nilachal Mission Trust BBS, seeking permission from the court to operate those bank accounts. Stop. Accordingly, the impugned order was passed, but the appellant, being the plaintiff in the said suit, is aggrieved by the said order, as according to him, the trust account is operated by the respondent number respondent number 4 from the inception, but later on, when the same intertrust dispute broke out and the civil suit was instituted, the respondent number 1, on assessment of the situation, stopped operation of those bank accounts. Stop. And the respondent number 4 was never allowed to operate the said bank account till the learned single judge passed the said order 7/9/2022. It may be mentioned here that what is the interim order first? Order number 10? What is the order? Interim order first in the repeal?
Yes, my lord. What was first? Order number 1, my lord, 21/9/2022.
It is required to be mentioned that by the order dated 21st September 2022, this court in IA number 2975 of 2022 had passed an interim order directing that there shall be stay of the impugned order dated 7/9/2022, passed by the learned single judge in WPC number 2372 of 2022 till the next date. Stop. And it continued till the date. Stop. Mr. Pari, S.S. Pari, learned counsel appearing for the appellant, has submitted that the appellant was totally deprived of was not given the opportunity to present his case. In this regard, he has referred to the impugned order, referred to paragraph 8 of the impugned order, where it has been recorded as follows. quote, the interveners and other trustees are added as party. Petitioner will file consolidated cost title. Stop. IN number 5507 of 2022 is allowed and disposed of. Now that all the trustees are parties to the writ petition, further directions are being made. Stop. And after that, the direction as reproduced before was issued. According to Mr. Pari, Learned Counsel, they filed the intervention petitions, but the court impleaded this appellant as the party, opposite party. So, the appellants and the party opposite parties, and the writ petitioner was asked to file the consolidated petition incorporating their name. Stop. It was expected that the appellants will be granted liberty to file their counter affidavit as they were made. They were arraigned as the party opposite parties. Stop. As they were arraigned as the opposite parties. Stop. But without granting, the final order was passed by disposing the writ petition. Mr. Pari, Learned Counsel has submitted that while they were making their submission on the intervention application, they have pointed out certain aspects but could not file any records, and also could not bring on record the subsequent development that has taken place. Stop. Mr. B. Rautre, Learned Senior Counsel, and Mr. P.K. Rautre, Learned Senior Counsel abstemiously argued before us that the appellants were given adequate opportunity to present their case at the time of hearing, but now they are raising that plea, they are not given the opportunity. Stop. That apart, the appellant number 4 has admitted that from the very inception, from the very day of the opening of the accounts in the name of the Nilachal Mission Trust, the bank accounts was being operated by the respondent number 4. Stop. And there had been no difficulty. Moreover, in the impugned order, a single judge has given a directions to prepare the statement of accounts and furnish to the all concerned. Mr. Vesage, there is no question of mismanaging the fund maintained in those bank accounts. Be that as it may, according to our considered view, the appellants had certain rights and they were supposed to get those rights, such as filing of the counter affidavit and along with the records, bringing on records the subsequent events which would have been considered by them as relevant. Stop. That apart, there is an issue now. That apart, there is an important issue that when an intra-trust dispute is the subject matter of a suit, whether such writ petition is maintainable or not. That aspect of the matter in the given circumstances was not considered by the learned single judge, considering the interest of the trust-instituted educational institutions. Stop. But still the jurisdictional aspects are required to be decided. Stop. But after the deliberation, a consensus has been made between the parties that the appellants will be given a week's time to file their counter affidavits, and thereafter the respondents number 4, 5, and 6 will get their opportunity to file the rejoinder again within the next 7 days after receipt of the copy of the contracted.
Only 4, because 5 and 6, they have also not arrayed in the writ petition. Only 4 is the party in the writ petition. 5 and 6 are still not.
All right.
Only 4.
All right. The writ petitioner will get the opportunity.
Writ petitioner, yes.
Rejoinder. I understood that already. Writ petitioner is the Nilachal Mission Trust. Trust.
Wanted to book an application request.
No. Just I will give it. Yes. The interim order
21-9.
Passed by this court on
21-9.
21-9. Passed by us, huh? Passed by us on 21/9/2022 as mentioned above shall continue. Till a decision is taken by the learned single judge, but we grant liberty to the writ petitioner to file any application for making bank operation on any emergency. So it is expected that the learned single judge, considering the nature of dispute involved in the writ petition, will decide the matter on with expedition. Stop. Anything more to add? I think
My lord has granted me 1 week. I only pray by 11th I will file. Because next week, most of the holidays, my lord, by 11th I will file.
Holidays are better for you. Time to prepare.
Yes, that is what I am saying. By 11th I will file, my lord.
all right. That it becomes 10 days.
Almost. My lord has said 1 week.
Let that time be granted, my lord.
All right.
But I have one prayer, my lord. Now that my client is added as a party in higher court, I mean appellate court, that's being an honorable single judge court, I will continue to be a party there also.
You can make
Because I have already, kindly, Mr. Party, it is not required, I am already.
We make. What is your difficulty? No.
They have not made.
Please, Mr. Party, you have made them party here.
Here, my lord.
Where have you made them if they are not party there?
My lord, I have said that all the trustees should be made party. They have not made.
That's why so he has understood the necessity of being in the proceedings. So we'll allow them to.
Yes, my lord.
The respondents number 5 and 6 in this appeal is headed by us as the opposite parties number 4, 5 and 4 and 5. Stop.
Perhaps already 6 is there. 7 and 8. They will be made 7 and 8.
7 and 8. After his improvement 6, 7 and 8.
Yes.
Stop. Have you filed the consolidated petition? No.
Yes, probably. Now we can find it. We'll find it. Because immediately we have to approach this court.
And the consolidated petition is directed by the learned single judge.
Yes. As directed by the honorable single judge.
Single judge.
No, that.
Now,
File. Yes, consolidated file.
All right.
yeah, constantly filed, but again, my learned senior's client will have to file one more. One more, because 7, 8 now.
Is a consolidated cost title only. We are not concerned with other. Cost title will be filed by the writ petitioner by this Monday is 4th of September 2023. Stop. Having observed this, we affirm the direction of the learned single judge in paragraph 8, but we set aside the direction at paragraph 9 of the imperial judgment. In terms of the above, this appeal stands disposed of.
Obliged, my lord.
8 is that your
Yes, ma'am.
party, if I also said that will be.
Obliged, ma'am. Highly.
Next. Is none. Oh, you are there, yes. Who is for the,
Yesterday I have no scope to remove the defect, hence I have filed the certificate of the judgment.
let us take the matter on Tuesday. Next Tuesday. List the matter on Tuesday. Mr. A. Majil and counsel appearing for the appellant has filed one memo.
Miller, Wednesday, kindly take no Wednesday.
Wednesday, okay. Wednesday and Thursday are holidays. Then it will go to the 13th of September. Let it be there.
Friday.
No, Friday we usually do not fix the matter. 13th of September, let it come. On 13th of September, the file signature is taken on record. Registry will make the necessary notes by the next date. Mr. M.K. Kuntial and counsel has appeared for the these respondents. All the respondents?
Yes, sir.
Respondents. All the respondents. Who is appearing for that criminal petition? And Ms. Patnaik is there, Mr. Katokia is there, yes. Yes. Let's take it there. These are in return to this council.
Yes, despite all sincere efforts, the owner pressed out. The transaction details have been verified. And also the CDR analysis and tracking reports plus by now even the police could not get a smell about where both the accused as well as the victim are. They are not using their mobile phones even. ATM cards, they are not doing any transactions. So we are trying hard to find them out.
You try, you're facing it again 14th of September again. Yes.
May I come in, my lord?
Yes.
Sorry, I'm sorry for joining actually. I wanted to assist my friend, my lord, because I just had a discussion with the IAC. He's saying one person of the village, namely Gullu Champati, he had assured the family that he is known to the accused. So he had assured the accused, the family of the petitioners that I will definitely bring the girl to you. There was a settlement, there was some settlement which did not work out. Now his house was also, a raid was conducted in his house. Now a CIG publication has been done. This is the development as of today.
14th September will be the next day.
My lord, lordship, repeatedly direction, my lord. The girl's age, my lord.
Again, repeating our directions. Yes. But Mr. J. Katokia, Leonard, Additional Government Advocate, and Ms. S. Patnaik, Leonard, Additional Government Advocate, appearing for the state stuff. It has been reported to us that despite the serious efforts taken by the police, the victim girl could not be traced out as yet. Though certain lead is available to the police, but they have to work on those leads to finally recover the victim stuff. By an order dated 11/7/2023, we directed
number 3 and 4.
Opposite parties number 3 and 4. We directed to take all efforts to find out the victim girl, but the police could not achieve the success. And despite their efforts, we still believe the police capability to recover the victim girl is reliable, and hence we further direct the superintendent of police in particular to lead the operations for recovering the victim recover the victim girl by the next date. Let the matter be listed on 14 September 2023. Mr. J.K. Khandathre, London Council, has appeared for the petitioner. A copy of this order is sent to the superintendent of police. It is the superintendent of police of which place?
Noyagarh, my lord.
For compliance stuff. As a measure of abundant caution, a copy of this order is supplied to the London Council appearing for the state.
Obligement.
When the matter was not listed on 29th, why did not you mention on 29th?
Sorry, my lord.
Now all of a sudden in Saturday, Saturday was not supposed to be the court day. This is the earlier case. This Okay, Mr. Rautri, I think it is given by Mr. Rautri. That's all?